Hearing the bill of one Chitolie and another against the same to the National Housing Corporation.
Ms. Dacey.
My Lords, I appear for the appellants in this matter. I have the assistance of Mr. Moores, who sits to my left, Mr. Theodore Casey, Miss Nelson appear for the respondent. Before I start, my Lords, can I just check that you have all the relevant material to hand? You should have, I hope, 3 bundles. One electronic bundle, which runs to 2791 pages, which has the authorities and the civil code at the back. A key documents bundle, which is in hard copy, which I will use for references to the judgments and to the risk cases.
Will you have all the pagination of the main bundle to help us with?
I will.
Yes.
The electronic bundle, my Lord.
Yes?
Yes. And a bundle of other legislation which has been provided more recently, for which we use the reference pagination LS, page number.
Yes.
That simply supplements the annex to our written case, which contains the legislation elsewhere in the in the Caribbean.
Yes, we do. For my part, it would help if we could stick as far as possible to the main hearing bundle.
Right. Well, I might have...
At least give us pagination from the main hearing bundle. Having to flick between 2 electronic bundles, both of which get to us through Adobe Acrobat, isn't like falling off a log.
No, I understand that. In terms of my plan, and I might have to revisit that given your Lordship's indication, was to refer to certain parts of the Court of Appeal judgment in the key documents bundle, simply because I have that in hard copy and I believed your Lordships have that too. But if I
don't have anything in hard copy. I see. For about 4 years.
Well, if I need the references, then we'll get them. I might. Yeah, that might just delay me a few moments.
But I mean, providing you can give us the where it is in the big bundle, that's not a problem at all, once you've got the pagination.
I'm grateful that, yes, I'll find them quickly, and I'll have the paragraph numbers, so it shouldn't take me too long. My Lord, if I can come straight to it, this is an appeal against a decision of the Eastern Caribbean Court of Appeal of St. Lucia. The judgment was January 2022. It's concerned with a few issues, my Lords, of statutory interpretation.
Just before we get into the detail, it's common ground, isn't it, that in this case there's no issues as to our jurisdiction?
It's common ground that there's no issues to your jurisdiction.
Thank you.
It's concerned with a few issues of statutory interpretation, and essentially the question is how the St. Lucian system of registration or title by registration interrelates with prescriptive rights, which qualify as overriding interests at the time of first registration. My Lords will have seen that the context of this appeal is that my client's case below relied on a number of things, but one thing, which is the thing with which we're concerned, is its long occupation of the northern part of what's known as Parcel 227, which is registered in the respondent's name. It's an area measuring just under 230 acres, and they relied on that long occupation both to defend the claim for possession which was brought against them by the respondents and to assert a claim to that area under the relevant provisions of the St. Lucian Civil Code. We say, my Lords, that on the Court of Appeal's findings, namely occupation of that area since at least 1976, that qualified as an overriding interest under Section 28F of the Land Registration Act at the time of first registration, namely 1987, which the respondent subsequently took subject to when it was registered owner in 2008. My Lords, it's common ground that my clients didn't bring a claim when the parcel was first registered in 1987, and essentially the question on this appeal, my Lords, is whether that matters.
Yeah.
The issues are agreed in the respective statements of fact and issues, and they extend to 5 issues. Issues 1 and 2, my Lords.
Page number?
Now. It's unfortunate. Key documents bundle, but I'll have to then...
Well, I'm in the key documents bundle.
Yeah, key documents bundle 1942.
If you're using the hard copy, the electronic bundle numbers are at the bottom of the page. So
it's the same as the electronic number, my Lord. I'm so grateful for that. So 1942. Yeah. So issues 1 and 2 are pure issues of construction, and they break down into three parts: whether it's necessary to bring a claim, whether time restarts on registration, and whether the court's jurisdiction is ousted. In combination, my lords, those issues make up the, quote, significant hurdles which we say the Court of Appeal erred in concluding were fatal to my client's claim.
What were those three sub-issues? How do you do?
They are, we've broken them down into three questions.
Where are they?
They're in the, it's 1942, my
Yes,
lord.
yeah.
Issues 1 and 2A and 2B.
Yeah.
Okay,
You
right.
see, so issue 1 is the claim
Yes, I see.
issue. 2A is the time issue, if you like. Does it interrupt time? Does it wipe the slate clean? And 2B is the jurisdiction issue.
And is it right that once we've answered those, there's no dispute about what the answers would then be to 3, 4 and 5?
Well, I think there is a dispute to this extent. We say that once we've answered those, if we're correct, we should be pushing at an open door. And the rest will follow. But I think it's said against me that there's an issue on our side as to the Court of Appeal's findings in terms of the quality of the occupation. In the respondent's case, it's said that there's a reference made to 88 people being in occupation of parcel 227, and thus the occupation not being sold. Now, my lord, I've got an answer to that. I say that's simply wrong on the evidence, which is what I've categorised as the Armbrister point in our written case. In a nutshell, my lords, we say that the evidence was squarely before the Court of Appeal. There's sufficient evidence which we say was not seriously challenged below, and there's enough, therefore, when we get there, if I get there, allow me to invite you to make the findings that we say are necessary. It may help you, my lord, to tell you what we're asking for at this stage. What we're asking for are declarations as to the construction of the statutory scheme. Firstly, that there's no need for a claim to be brought during the adjudication period in respect of rights which qualify as overriding interests. Secondly, that on a true construction of the scheme, first registration of title does not interrupt the prescription period. And thirdly, that there is no jurisdictional hurdle to the court considering a claim as to the ownership of land based on prescription, which is the subject of Section 28, that's the overriding interest provision, and or a defence, because we put it by way of defence and claim.
Are these set out in the documents we have?
What I'm asking for isn't set out in those terms, Mike.
Could you possibly put it on
A piece of paper
and let us have it, I mean electronically?
Happily, yes, and I won't waste time then. So essentially declarations, and we say that consequential declarations would be findings, and I'll put it on a piece of paper, as my lord has requested.
I mean, I don't know whether the respondents have had notice of these proposed declarations.
Well, my lord, it's clear. These are, it's obvious, we say, from how we put the case, that that's...
I know, but it's useful to know the
Yes.
the precise relief that you're seeking,
Indeed.
both for us and for the respondents.
We'll put it on a piece of paper over the lunch.
Much obliged.
So, my lord, we've added in the written case, you'll see on the page that we were just looking at, it's on our written case. In the appellant's written case, we've added another issue, issue 7, which is on page 1991. That the approach of the Court of Appeal, we say, would have serious implications. That's, my lords, essentially a bolt-on point, if I can put it that way, to points 1 to 3. We say that if we were to construe the scheme in the way the Court of Appeal did, the effect isn't necessarily limited to St Lucia, because there are similar provisions in other Caribbean countries, hence our annex to the written case, where the similar provisions effectively, the effect would travel, if you like. So that's, but it's not a standalone point, it's essentially a bolt-on point, just so that your lordships are aware of the context.
Can I just be clear, if I may? At the time of first registration of the land we're concerned with, am I right in thinking that that your clients did not have an accrued possessory title?
My Lord, on the Court of Appeal's findings, they didn't, because the Court of Appeal found...
Well, we're not departing from
You're not
those
departing,
findings.
so
So
we're
the answer is
proceeding.
here,
Yes.
you did not have an accrued possessory title.
Indeed, we're proceeding
Do
on
your
that.
issues sort of focus on that? It doesn't, it seems to me you focusing on what the position would be if you had, in 1987, an accrued possessory title, but you didn't. So are you going to be addressing that aspect?
Yes, my Lord, I am, because Section 28F specifically refers not only to rights acquired, but rights in the course of being acquired.
Yeah.
Those two elements. So in order to qualify under Section 28, one can be a person with a complete 30-year period, or one can be a person falling short.
The nub issue in this case is of someone who does not have a possessory title at the date of first registration.
It is, but their broader point, which we're inviting your lordships to look at, is what is the effect of the Section 28 carve-out?
Oh, I understand that.
And that
I understand
includes accrued rights.
Yes,
And we say you can't separate out the two.
So the answer to one answers the other.
Indeed. So it might be said that we're, and for various reasons I'm going to go into in more detail, we're in a better position because on the language, for example, one of my arguments in relation to don't need to bring a claim is how can one bring a claim in relation to rights in the course of being acquired when one doesn't yet have a claim to an interest. So it might be said I'm in a better position than someone who had an accrued right in respect of which a claim could have been brought. But if I were in such a position, my argument would be essentially the same, because I'd be saying Section 28 includes accrued rights, and there's still nothing clear in the Land Adjudication Act which requires a claim to be brought. My Lord, before I make submissions in relation to those three questions of interpretation, it may be helpful to look at some of the relevant passages from the Court of Appeal judgment in order to place the hurdles which they found to be present in context. And I'm hoping the page numbers are going to be the same. So 933. Yes, excellent. Paragraph 113 is the paragraph where they identify those two hurdles. The bottom of page 933 faces two significant hurdles, and then over the page, the first is that the conjoined effect is that adjudication and first registration interrupts rights which have been or were being acquired, so both prior to first registration, and accordingly, this is the second hurdle, no it's not, but it's a follow-on point, not to be counted. That's question 2.
Where are we now?
And then the second hurdle relates to the jurisdiction. So that paragraph identifies the three questions. And then at page...
I'm sorry, I'm being slow here. This is in the main bundle.
In the main bundle, 933, my Lord.
What are we looking at here?
We're looking at paragraph 113.
Right.
At the bottom of page 933.
Right, okay. Yeah.
Yeah, and you see, my Lord, the last line refers to two significant hurdles.
Yes, thank you.
Yeah. And then you see on the next page the elements which make up the three questions which we've identified.
Mm-hmm.
Does the second point affect a purely defensive stance? I mean, this is about jurisdiction to determine claims for prescriptive title.
Yes.
At any rate, it's formulated by the Court of Appeal.
My Lord, it doesn't, in the sense that the Court of Appeal, as we will identify, seem to accept, and this is 979 of the key documents bundle, that in relation to a defence, there's no jurisdictional hurdle. It's paragraph 204 at page 979. So if we're right about questions 1 and 2, i.e. no claim needs to be brought and time doesn't stop, then hopefully you'll be with me in relation to the defence on jurisdiction. But, my Lord, it does affect the claim. And in a nutshell, the position there is whether or not the Act, the scheme, contains sufficient mechanisms whereby the court's jurisdiction is retained. The next paragraph is at page 943. Paragraph 133. So at the top of the paragraph, the Court of Appeal makes a finding about occupation, but if I can ask my lords to track down to the 4 lines from the bottom, starting the main issue on this aspect, is whether the appellants, having not claimed during the LRTP, that's the Land Registration Title Project, the Act of First Registration, the vesting effectively bars the appellant from claiming, so as to defeat any claim to an overriding interest based on actual occupation or limitation or prescription. That's the question that was posed. And at page 959, paragraph 164, they held that the appellants, having not claimed, can no longer, by way of defence and counterclaim, assert a possessory right or interest acquired prior to. So that's my Lord Briggs's point. It's the focus there is on assertion of a claim.
What could you have claimed? What could the appellants have claimed at that point on the findings?
As at 1987. On the findings, we couldn't have made a claim. That's one of my...
But so what, I'm just wondering what they're meaning when they say the appellants having not claimed the disputed land.
It's in the context of the overriding interest which we say was present in 1987, having continued to subsist thereafter because we continued...
No, but they say here, the appellants having not claimed the disputed land during the LRTP. My question is, what claim could your clients have made?
Well, precisely.
Well, the answer is...
The answer is there was not, on the Court of Appeal's findings, there was not yet a crystallised...
We're proceeding on the Court of Appeal's findings.
There was not yet a crystallised interest which was capable of forming the subject of the claim. At best, my lord, we could have flagged the fact that we were in occupation and thereby put our head above the parapet, which we say would have sounded the death knell to any prospect of...
All right, you'll show us the legislative provisions which would have enabled you to do that, will you?
Well, there are none. That's our
how
point.
Could you? That's the point I'm making.
No,
I don't understand the point the Court of Appeal is making.
Well, my lord, that's why I say they're wrong, because we're saying there's no need for a claim to...
There's no way you could have put your head above the parapet.
So question 1 is, should a claim have been brought? They say yes. If you don't bring a claim in respect of an overriding interest, which includes rights in the course of being acquired, then you lose the rights. We say that's self-evidently wrong, and the best point, I think, my lord, is identified in support of our position in relation to that, is it's simply not possible to bring a claim in relation
to... Well, the most you could do is put your flag up over the parapet and ask the adjudicator or the certification officer to record that you had done so in some way on the title, but then one asks what on earth would appear on the other person's title absolute in that.
Well, indeed, and in any event, that would then constitute an interruption, and as I say, sound the death knell for any prospect of us being able to complete the period.
We need to see what in the legislative scheme would enable you. I'm not saying this instant we need to see that, but in the course of your submissions and those of the respondents, we need to see in the legislative scheme how, as you put it, or how it's been put, you could have put your head above the parapet.
Yes, indeed. Well, that's a point.
I mean, what procedure was there for you doing so, and what procedure was there for the adjudicator to make any entry?
Yes. Well, quite. I will take you to the provisions. So the next...
Can I just before you go on, you mentioned it would be the death knell. Why would it be the death knell if you had to flag your interest?
Because if the purpose of an overriding interest, and I'll take you to policy in a moment, but what we say in a nutshell is that there's an express carve-out for good policy reasons, which is effectively an exception to complete indivisibility of title.
Yeah.
And that's the reason for that, in short, is because these types of rights are considered to be arising informally. It wouldn't be reasonable to expect them to be registered necessarily. If you're in the course of acquiring a right by long occupation, yet you haven't got the complete period, and you have to bring a claim in relation to that, you have to say, I've got 10 years of a long occupation, so 20 years short. The person who's asking for the land to be registered in the name then is alerted to the fact that you're in occupation of the land and can then serve you with a claim, and that interrupts your
it's a practical death knell. It's not a legal death knell.
No, it's not a legal death knell.
They may or may not do that.
My point is, if the purpose is to preserve these rights, well, by requiring a claim to be brought, that preservation is undermined.
Well, I'm not sure there's any legislative policy to preserve a trespasser's occupation of the land.
By the overriding interests are
You only get that once your period of occupation.
Indeed, but the legislature, we say, included in that category rights in the course of being acquired.
But we'll need to understand that.
Yes.
Yeah.
Before doing so, just the overriding interest in land is defined as a right in the process of being acquired.
Yes.
And under Section 8 of the Land Adjudication Act, there's an obligation, mandatory obligation, to claim an interest in land.
Yes.
And so at that stage, is the interest in land under the Land Adjudication Act the same as a right in the process of being acquired?
Well, there is to overriding interest, that's the phrase, but that includes rights. So rights and interests aren't necessarily the same thing. My Lord, you're right that the Land Adjudication Act refers to interest. I think there's a definition which says that any interest in land that could have been the subject of a note on the register.
Yes.
Yes.
Then we don't
Being recorded under the provisions.
Yeah,
Yes.
but we say we wouldn't. It's the same point, I think. We don't have an interest which could have formed the subject of the claim. But I'll take you to the provisions. I just wanted to put the questions into context so that you had your eye firmly on how the Court of Appeal approached it. At the outset, 971, please. Paragraph 184. And this is to the point. The Court of Appeal held that by virtue of Section 8, my Lord Stephen's point, that section was referred to. And then 185, it's that the scheme clearly contemplates that a person who claims land, including an overriding interest, must have signified that interest during the title project. Pursuant to Section 6, that's another section we'll need to look at, by making a claim, and then reference is also made to Sections 16 and 18. And then at 188 over the page, my Lords, page 972, you have the finding about time of occupation. And then 189, it said that law was clear, the first registration extinguished any claim which they had acquired or may have been in the process of acquiring based on their actual occupation.
I'm sorry, which was that paragraph?
189, my Lord. And then finally, at page 976, paragraph 198, it refers to George and Charlemagne. It's 5 lines from the bottom. That decision serves to illustrate that an interest acquired after first registration can become the subject of overriding interest acquired or in the process of being acquired thereafter, including. So it seems to be being said that overriding interest, if you don't bring a claim, can operate prospectively, in the sense that they can be acquired or in the process of acquired thereafter, but not at the time. My Lord, I don't understand it to be controversial that the effect of that decision is that a claim has to be brought by anyone in respect of any rights accrued to them or in the course of being accrued, or they face the loss of such rights. The clock's set back to 0. That's the first practical consequence. Secondly, that consequence, my Lords, applies regardless of actual notice of the adjudication process, regardless of whether they knew they had rights. And it's notable, we say, that there's no provision for personal service, and I'll take you to that in a moment, under the adjudication scheme.
Just before we move on from this background, I appreciate we've got to focus on the findings as made by the Court of Appeal, but am I right in thinking that in fact your clients were asserting that they'd been in actual occupation for some 100 years
Yes.
or something like that? So according to their case, it might be said that they could have brought forward a claim under Section 8 because they were claiming a full prescriptive title to the land as at the time of the LRTP. Is that right?
It is right, my Lord, and it is said that they should have brought a claim because there was a claim. I mean, I think it's fair to say that there was a somewhat of a scattergun approach into the way it was presented below. A number of claims are being asserted.
Well, they were even relying on some form of paper title to some
Indeed, so that the primary case is paper title. And then long occupation spanning, as my Lord says, 100 years.
But all that failed.
And there was confusion about the area of land. There was a claim brought under the adjudication process in relation to a different parcel, and that's the point that's made against me.
Yes.
But there is, my Lord, I think it's important to flag an unresolved factual issue. My clients were told, they say, by the adjudication officer that he would come back, and they say they were unfamiliar with the process, and that was never resolved. But we said that even though they could have brought a claim, one can't assume that they should have in the circumstances if they did have that conversation with the adjudication officer. So it's not as straightforward as...
I thought there was, one of the matters the Court of Appeal dealt with was a claim for rectification based on mistake.
Yes.
And that did involve the process, what was said to be defaults in the process. I haven't focused very much on it.
That was one of the...
You're talking about something else,
I'm talking about something else.
Right.
As I say, there was a rather kitchen sink approach. There was a claim in relation to rectification. But that does not form the subject of this appeal.
No, indeed.
Just one of the ways...
We better keep our eyes on the main target.
Indeed, indeed.
But the reason I raised my point was it seems to me it potentially goes to the question of statutory construction as to what is the effect of Section 6 and Section 8 of the LAA in relation to a claim where rights are in the process of being acquired. If you could bring a claim where you are maintaining that rights have in fact been acquired, I mean, it seems to set up what might be thought to be a slightly odd dissonance that you, if your case is, I've got full prescriptive rights, and you could bring that claim forward under Section 8, and you lose on that, but you in some ways get a better right that escapes the effects of Section 8, where you say, well, even if I lose that, I'm in the process of acquiring prescriptive rights.
Well,
Because I've lost on my claim for 100 years, and I'm less than, I think it's 30 years.
Yes. Well, my Lord, I think the claim, that would be...
I'm just raising it so that you can deal with it
Indeed.
at
Well,
some
the
point.
short reaction to that would be that's a res judicata type point. If you've made your claim, then you're in rectification territory because it's the same claim. But if you've never brought a claim at all, I will take you to the provisions. There is provision, we say, in the LRA, which allows the court to make determinations in relation to overriding interest. Obviously, if a claim's been brought, determined, rejected, then but that's not the case here.
Right, but I thought it was being said against you that under Section 8 you have to bring forward a claim if you've got one in the LRTP process.
It is.
And if you don't,
It is.
that's going to be fatal to you asserting that claim.
It is.
The point that I'm trying just to raise with you so you can deal with it at some point is if that argument is correct, you may say it isn't, and you'll explain why, it just might be thought to be slightly odd that that argument would defeat someone that's got the bigger claim because they say, I've been in occupation 100 years, and they could bring that claim, but would not defeat a claim that's in the process,
Yes.
because someone's been in occupation for less time
Yes.
than that.
Well, my Lord, I think, sorry, I shouldn't, yes, I think the short answer is you don't need to bring a claim. But I'll take you to the scheme.
All right,
as to
okay,
why.
so-
And that would be a reason why our construction is right. Another
Right,
reason.
okay.
In addition to the absence of clear words to the effect that claim is mandatory.
Bit like a dog with two tails, and the question is which one is wagging the dog.
Indeed. Right. So before I turn to question one, I just want to flag the reasons why we say the Court of Appeal's construction is wrong across the board. Firstly, a construction which results in the loss of accrued rights would require clear words, and we say they're not to be found. That's number one. Secondly, the construction runs against or reads down the express statutory language, which will take you to, which makes it clear that registered title is not entirely indefeasible. Thirdly, the construction cuts across the law of prescription. It leaves no room for the formal acquisition of rights unless they're brought to the attention and dealt with at the time. And fourthly, my lords, it neglects to appreciate that there are statutory mechanisms, which we'll take you to, which we contend on a true construction of the scheme retain the court's jurisdiction and enables the scheme to coexist with the existing law.
My fault, I wasn't writing fast enough. What was your third point?
Third
Sorry.
was cuts across the law of prescription, informal acquisition of rights. And fourth, neglects to appreciate the statutory mechanisms which retain jurisdiction of the court.
Yes, thank you.
Yeah.
And then finally, before I start, in terms of authority, we say the thrust of the authority is with us, not the respondent, and the Court of Appeal wrongly distinguished the board's decision in Davies and the decision of the Caribbean Court of Justice in George and Guy, which we contend contains similarly carve-out provisions and policy considerations. And it also wrongly followed, we say, the decision in Joseph, which was relating to the running of time, and the decision of the High Court in James and Plevin. So, question one. The statutory framework, my lords, as we've seen, is the LRA and the LAA. They were both adopted in the early 1980s. I'm sure your lordships know this, but it's inspired by the Torrens system of registration. And the purpose, essentially, is it's a system of title by registration rather than registration of title. And what it essentially did was replace the previous system, which required investigations to be made to ensure the validity of deeds, which would involve laborious and costly title searches, with a new system whereby each title was examined, title was guaranteed by the state. So in a sense, the new system did away with the need to look behind and to investigate the chain of title.
So there was no statutory system at all before.
Well, it was just registration of deeds.
Indeed, it was the
was a registration
by
of
deeds.
Yeah.
Yes.
It was registration.
Registration by deed, yes.
And deeds registration presumably had the effect of putting third parties on notice of the rights conferred by the deed. I mean,
Yes, I
keyed
have.
into an essentially,
Yes.
well, a mainly common law basis of land ownership, although
Indeed.
of course in St Lucia it's always been a mixture of that and
Yes.
the civil code.
Yes. What this system did was effectively to create a new system whereby you have the adjudication process, and I'll take you to that in a moment, and once you've got that, you can, a purchaser can have more comfort that the title is valid, subject to the provisions of the scheme.
There was a prior statutory scheme of some sort, was there?
Do we know that? We haven't looked behind.
Okay. I mean, I make the point because, of course, in Antigua, as we know, there was.
There was in the 18,
And I wondered whether there was a
1887
similar
legislation.
system in St Lucia.
I'll find out the answer,
Thank you.
my lord. I don't believe so.
Okay.
But I'll find out. It's important, my lords, when one considers the new scheme, to bear in mind what Sir Terence Atherton said. As we've noted in our written case in Richardson, he said that the Torrens system's objective to achieve absolute and indefeasible or unimpeachable titles has never been achieved because of exceptions to the principle of indefeasibility. And we emphasise that.
Do you have a page number for that?
I do, 2454, paragraph 13. So, my lords, turning to the relevant statutes, the LAA, that's an act to provide for the, as 2021, it's an act to provide for adjudication of rights. It's essentially concerned with the short-term activity of surveying and producing adjudication records. And the LRA is at 2036, is an act in contrast which has 119 sections and provides not only for first registration but for the operation of a whole system of registered land for the indefinite future. My lords, I'm going to ask you to look at the provisions of the LRA first, and the reason for that is because the LLA makes, section 23 of the LAA says it takes subject to the LRA, so let's look at what it takes subject to before looking at the LAA.
And also, the scheme under the LRA is the continuing enduring
Indeed.
scheme.
It's
And the LAA simply means of getting started quick.
important but short-term activity, which is, I think, how the board described it in the case of Lewison, yes. So, the LRA, as you'll see on page 2036, the index is on 2037. It's divided into 12 parts, my lords. Part 3 on page 2038 is concerned with the effect of registration. And so we need to look at that. Then, in terms of the index, I'll take your lordships also to part 7, which contains section 80, that's transmissions, and part 9, which is on page 2040, prescription, then you've got rectification, which we don't think need to concern ourselves with, and then part 12 and section 115, which is jurisdiction. 2038. Oh no, so sorry. Before we move forward, so 2043 is the definition of transmission. You might want to flag that at this stage because I'm going to take you to it in relation to section 80. It means the passing of land from one person to another by operation of law, on death or insolvency or otherwise. 2047, section 9 refers to the land register, and skip over that, and 2058. 2058, section 11, deals with registration. Section 11? No, I've got my references wrong, so sorry. Section 11, 2048 probably. 2048, yeah.
Sorry, I missed that page.
2048.
2048, thank you.
Deals with section 11, preparation of a register, and then 12, cancellation of an entry by the registrar.
But before leaving section 9, the provision in subsection 2 is the register shall be divided into 3 sections. The property section, the proprietorship section, and then C, the encumbrance section, containing a note of every encumbrance and every right adversely affecting the land or lease. And so the right there is what?
Rights which have been, because there is provision. I'll take you to the LAA. They can be registered, but they don't need to be.
Right.
Yeah. So section 28 then is the, sorry, I'll take you to section 23 now, 2053, which is in part 3, effect on registration. So, my lords, you'll see that it says here, subject to the provisions of 27 and 28, the registration of any person as proprietor with absolute title shall vest in that person absolute ownership, together with all rights and privileges, free from all other interests and claims, but subject, B, unless the contrary is expressed in the register, so they can be expressed, to such liabilities, rights and interests as affect the same and are declared by section 28 as not requiring noting on the register. And the similar provision in 24 with provisional title, my lords, that doesn't apply here because the respondent is registered with absolute title. And at page 2054 is the key provision overriding interests. Unless the contrary is expressed in the register, all registered land shall be subject such as the following overriding interests as may subsist in effect without their being noted. So A and B, we can skip over the key ones for our purposes.
Why under A is it servitudes at the time of first registration, whereas that qualification doesn't exist in the subsequent ones? Why use those words at the time of first registration?
Well, my lord, I'm afraid I don't know the answer to that, but it's your right to say that those words don't appear in F or G. In fact, F and G are expanding beyond rights subsisting as at first registration to include rights in the process of being acquired. The definition of servitude...
Is there a procedure under the LRA for registering servitudes or rights in respect of servitudes which come into being after first registration?
There may be, I think maybe 96, but that's,
So would it, I mean, subject to servitudes falling within B, would it mean that any other servitude which comes into existence after first registration is not an overriding interest?
My lord, I'll check that point. But for our purposes, we're looking at F and G.
Well, you could acquire a servitude by prescription, couldn't you, under F?
You could
Well, you
acquire...
require an easement by prescription. I'm not sure I know enough about the difference in an easement.
No, let me look at the definition of servitude. That's in section 2. Sorry, if I can just go back to that. It's around 2037.
It takes you to the civil code, doesn't it? That we haven't got.
You have got the civil code.
Have we?
Yeah, it's at the back of the authorities bundle. So servitude is defined at... Yes, it's page 2043. Yes, you're quite right, my lord. You're ahead of me. 449, which we don't have that particular article. You're quite right. You're ahead of me. But we can find it if that would help.
Oh, there it is. Yes.
Yes, 449. We can pull up the relevant provision of the civil code over lunch.
Yeah.
Yeah. So if I can go back then to 2054, which is section 28, and F and G, which is at 2055. Rights acquired or in the process of being acquired by virtue of any law relating to the limitation of action or by prescription. And then you've also got G, which is the rights of a person in actual occupation or rights to the income, save where inquiry is made and the rights are not disclosed. For the purposes of this appeal, we rely on F. We say, my lords, it's clear linguistically that this is an express statutory directive. All land shall be subject to, and it operates as an exception, if you like, a crack in the mirror of title. And I'll take you to the Law Commission report in due course, whereby there was analysis of the England and Wales 1925 Land Registration Acts, which reflects, if you like, this language and explains the policy justification.
Does it explain the words "or in process of being"?
Yes, my lord. There's a helpful reference in there.
All right, thank you.
I can't. Are you going to jump past the last 3 lines of section 28?
However, the registrar may direct registration in such manner as he or she thinks fit.
Yes.
So
And I'm just thinking that, bearing in mind we have to construe this together with the Land Adjudication Act, it appears to suggest that although overriding interests don't have to be registered, they can be at the registrar's discretion.
I don't dispute that.
And there might be, as it were, a think across to the Land Adjudication Act.
Indeed. Well,
might be included, even though it doesn't have to be.
yes, indeed. There is
And
power.
the public interest that would be served by doing so in terms of resolving what would otherwise be doubts about an essentially unwritten, unregistered title.
Yes. Well, when I take you to the LAA, the Land Adjudication Act, there is power for a registrar who operates a quasi-judicial role. There's power to consider prescriptive rights. And we say that doesn't point against a claim being mandated. We say simply what that does is empower a registrar in an appropriate case to make that determination, and that the presumed policy purpose is to ensure that when you're adjudicating, you're mopping up as many rights as possible to save the court having to deal with them later.
Yes.
But that doesn't mandate the claim needing to be brought at the time of first registration.
But just so I can fully understand, you're accepting that the registrar may direct registration of rights being acquired in the process of being acquired.
Well, may direct. I say that has to be construed against the in context, and they can only direct registration of interests which can be registered. And I say in the context of a right in the course of being acquired, it's not easy to see what the registration would be, because there is no interest that has yet crystallised. So it may, but it doesn't need to, and it depends on the circumstances. Although I recognise, my lord, that it says of any of the liabilities here and before defined, so that seems to be inclusive language, as he or she thinks fit. But it's a quasi-judicial duty, so they have to exercise it in a way that would, if I may say, be sensible and appropriate.
Yeah.
Okay.
Can I, just before we leave this, just looking at paragraph D, which is short leases to 2 years or less. If the Court of Appeal is right, then would this follow that if there were in existence a 2-year lease, which, for example, had 1 more year to run at the date of first registration, that would have to be the subject of a claim under sections 6 and 8? If the Court of Appeal is right.
Well, it doesn't qualify as an overriding interest. You either, in order to...
I mean, their point is that if you've got that an overriding interest is one that arises after first registration, that if there's an interest even though it might be an overriding interest under Section 28. If it exists prior to first registration, it must be the subject of a claim.
Yes.
Otherwise, it's lost.
Indeed.
So, are they saying then, would that mean that a lease, 2-year lease, but which was, let's say, halfway through, I mean, what would be the effect on their reasoning of a failure to assert that claim under the LAA?
Well, my lord, the effect, as I understand it, which is why I said the practical, there doesn't seem to be any dispute with the practical consequences if you don't bring a claim in relation to any rights, including overriding interests, then the rights are lost.
So you'd lose your rights as a lessee in that case.
And we say that's why the first principle as to why we say it's wrong is it requires clear language. It results in the loss of rights. That would require clear language, which is not to be found.
Well, a lessee might be supposed to know that the adjudication process is going on. But what about the chargee under subparagraph E? Well, he might live on the other side of the world, and because of some dispute or other, or some debt owed, got himself a charge over the land, which, if the Court of Appeal's analysis applies across the board to all overriding interests, he'd lose unless he asserted it during the adjudication process.
That's the effect of it, my lord. And I say we can't descend into a construction which depends on the subjective knowledge of the particular individual at the particular time.
No.
It has to be determined by reference to a general principle that applies across the board and is sufficiently certain and sufficiently in accord with the presumed policy purpose.
It has to be expressly declared by any law. So it's not a consensual arrangement, is it, that is referred to in E, which is that right? Because I mean, it's a little bit, in that sense, maybe a bit like electricity, electric supply lines,
Yes.
or rights of compulsory purchase, which is in C. These are rights which are conferred by law.
Yes. It doesn't say
And
by
so,
statute, but yes.
You know,
But it does say
it'd be hard to see that powers and rights conferred by law, let's say a public act, would be lost because they weren't asserted as part of the LAA
Yes.
process. So they may be in a somewhat different category, mightn't
I
they?
see that.
I don't know. I mean, it's just a...
But on the Court of Appeal's on the Court of Appeal's findings, it's across the board.
Yeah.
Well, that's what I'm just wondering. They haven't addressed
No.
sort of rights of compulsory acquisition vested in public authorities, for
They
example.
didn't need to. They had simply this in
exactly.
mind. But
It might be
on the
a bit-
language they used,
Yeah,
yes.
well...
And it may well be that they were simply having the sections in mind that they were specifically concerned with.
Did I understand you to say you're not placing any weight on G? You're purely placing your case on F?
G was relied on below, and G is a bolt-on, but I'm focusing on F.
Yeah, I think you make it clear in your case that
Yeah.
this case is brought on the basis of F, not G.
Yeah, and that's
And
because...
that's what you opened with.
Yes.
Well, indeed, that's right. And the reason for that is we're in the course of being acquired, you see, and if we're in the course of being acquired, then we don't have rights which are capable of forming the subject of G. Right. So, my lord, I just remind you that in order to qualify under F, you have to have acquired by virtue of any law relating to limitation or prescription. The underlying law for F are the provisions of the Civil Code, which sets out a 30-year prescription period. And as we explain in our written case, that can operate as both a shield and a sword, so negative and positive prescription. We say, my lord, the clear objective of F, 28F, is to provide protection both persons who acquired rights at the time of first registration and also those in the course of acquiring rights by operation of law. And in that way, the protection, as we've discussed, extends not only to persons who've achieved the full 30 years, but also those who haven't. Essentially, the intention appears to have been to retain the traditional doctrine of adverse possession as an exception to indefeasibility. And the effect, as we say, to create a crack in the mirror of title. My lord, the respondent refers in the written case to the policy to keep to a minimum the number of matters which may defeat the title of a registered proprietor. Well, that may be so, but one needs to keep in mind that certainty of title must be balanced against the fact that the mirror principle can only prevail at the expense of restricting someone else's rights. And overriding interests, which are a common feature of registered conveyancing, have the effect of preserving a certain category of rights where there's considered to be a sufficient policy justification. And in doing so, it operates to maintain the balance as the draftsman saw fit. So My Lords, I mentioned that the sections mimic the language of the old Section 71FG of the old 1925 LRA. I'd invite your Lordships to look at the Law Commission report, which was published in 1987 as part of a general review of that statute. 2651 is where it starts. And it was, as I say, part of a review of the LRA. It made recommendations about title reform, but ultimately it concluded that there was sufficient policy justification for retaining the old sections F and G, and the law wasn't changed until 2002, as we no doubt all know. So the relevant references, which we say are pointers in this case, start at 2659. 2.1 just puts it into context. The Land Registration Act makes broadly 4 classifications, little 3 overriding interests. And then 2.2 refers to the fact that it's one of the 4 classes to have been criticised as a concept. And there's a reference to a quote about the mirror principle never being complete until everything is on the register. And 2.4 over the page, my Lord, sorry to take this quickly, I'm conscious of time. 2.4 makes the point that overriding interest can be matters of value. Next page is 2661. Paragraph 2.6 refers to the theoretical idea of the mirror principle, which can, and I use the quote, can only prevail at the expense of restricting someone else's rights. And then at the bottom of that page, my Lords, the sentence starting, these considerations persuade us, about 5 lines from the bottom, 2 principles. First, in the interest of certainty and simplifying, a class of rights which may bind a purchaser should be as narrow as possible. 2, interest should be overriding where protection against purchasers is needed, yet it is neither reasonable nor to expect nor sensible to require an entry on the register. So those are the 2 principles which were flagged. And then at 2663, my Lords. 2663? Yeah, 2.8. The Law Commission looked at the list of right you see there. Our first task is to look closely at the present risk with a view to deciding how far the paragraphs can be paired. And at the bottom of the page, 2.10, there's a reference to rectification and overriding interest. They're different things. And then 2670 at 2.23. Right, having analysed the position, they refer then to the remaining heads of overriding interests and list them. And then over the page at 2.24, the conclusion appears, applying the 2 principles explained, we consider the only candidates for continued overriding interest status comes within the following subheads, and they're listed. They include rights by adverse possession, rights of persons in actual occupation, 2.24, and then 2671. At the bottom of the page, 2.27, under the heading arising by operation of law, you'll see there's a reference to that, including rights by prescription, last 3 words in that paragraph on that page. And then 2672, my Lords, at 2.30, there's a recommendation in relation to easements by prescription. It's said to be the case for easements arising in the ways mentioned is irresistible. And then to the next, skip over the next sentence, or if you can look at it, but then the sentence starting, in our view, such rights arising by operation of law provide support for the status quo in relations between landowners. And then, my Lords, 2673 over the page, down the bottom, refers to adverse possession. It's my Lord Richard's question, 2.36. Under this heading are now included rights acquired or in the course of being acquired, under the Limitation Act. The acquisition of rights by adverse possession under the general law must be regarded as outside the scope of the present report. But last sentence, accordingly, we consider such rights can continue to be accommodated acceptably in the registration of titles overriding interest, and so we recommend. Then the next paragraph, however, a right in the course of acquisition but not yet acquired for obvious reasons can't strictly be treated as an overriding interest within section 71. The reference to such rights is understood to signify simply that time should not start to run again on registration of a new proprietor, i.e. for the 12 years in that case, but without prejudice to whether or not the squatter could be evicted in the meantime. We consider and recommend this is practical and fair, better preserved, well, with the direct provision separately, but that's not the case here. And then you'll see, my lord, the recommendation, there's a footnote 108, which is attached to the recommendation to keep overriding interest as adverse possession as an overriding interest, that the approach was supported throughout the consultations. That's footnote 108 on page 2674. And then, my lords, finally, I don't need to take you to that, so I'll leave that out. So, my lords, if I can take you back to the wording of 28F.
Could I just ask you
Yes.
this? Was the recommendation made by the Law Commission at the end of paragraph 2.37 followed through? So is there now a statutory provision which gives effect to that recommendation?
Well,
Better preserved by a direct provision separately from the provisions?
No.
Not-
It was, so the old language, section 71 F and G stayed until the 2002 Act, which did away with, which pared down still further the categories of overriding interest. So
Okay.
nothing between the 25 Act and the 2002 Act.
Did rights being acquired by prescription disappear under the 2002 Act? Or are they still there?
I should know the answer to that, my lord. They are, no, they're paired. No, they didn't, I don't think,
Someone with a laptop can look well.
someone with a laptop, my lord, you might know the point. Do you know the answer?
It's much more difficult anyway.
But if I may say so, for present purposes, I'm simply referring to the 25
fine.
Act because it reflects the
I was
language.
interested, if they had enacted something, it would have
Yes.
been interesting to see what it was.
Yes.
That's fine.
So if we can go back to section 28 at 2054. I've made the submission, but I just to make it clear, we say that the words "in the course of being acquired" do not sit at all well with the notion that a qualifying person must bring a claim. And that gives rise, we say, to two immediate questions. What would the claim be for? And second, how is the intended preservation to be effective if the claim were required in respect of rights in the course of being acquired? As the law says, the language signifies that time should not start again, but without prejudice to the squatter being evicted in the meantime, if they were required to bring a claim at the time, so before they had an interest. And as I said, that practically makes it very difficult for them to complete the period. We also submit, my lord, that the words "as may subsist" in the first part of section 28 and affect the same don't sit well with the notion that overriding interests are only intended to be operating prospectively if you don't bring a claim. As may subsist, that means, in our view, in our submission at the time, so any overriding interests that are there at the time of first registration. Or from time to time.
Sorry, can you just repeat the point?
The words "as may subsist" is not limited to after first registration. It extends, it's a general language which encompasses overriding interests that are present and as may subsist at any point in time, including...
So before and after.
Well, before first registration is a slightly arcane concept.
Well, yes, at.
Oh, that's right, at the time, at that point in time, yes.
Yes.
My lords, if I can just take you to one authority, very briefly, I'll ask you at least to note it. It's the case of Ad Rural and Gede, Court of Appeal decision in St Lucia, at page 2127, which we say is a correct application of section 28F. And it's a case where siblings of Mary Ad Rural had essentially were claiming the land was theirs by prescription,
I'm sorry, I missed the page reference.
Sorry, 2127 is where it starts. It involved a claim against the registered proprietor. The contention was that the land in fact belonged to the respondents. Important to bear in mind that no claim had been brought at the time, so that's paragraph 4 at 2128. None of her siblings made any contrary claims to the land. The trial judge ordered that title in the appellant's name be cancelled, and that the respondents should be registered as owners. You see that, my lords, at paragraph 1, last sentence. And at 2129, paragraph 6, the two grounds of appeal for my purposes are the last two: whether the judge erred in law when he determined the case on the basis of their prescriptive title, and whether section 28G was inapplicable. And at paragraph 11 at page 2131, brief reference is made to section 98. That's not the right section to make, which empowers the court to make declarations regarding overriding interests. So that point was made, and we say was correct. So the court moved on at paragraph 12. Well, at the bottom of paragraph 12, there's the line starting, "The Land Registration Act clearly gave the court power to make the order, as will be seen when we examine section 28. And then at page 2132, my lords, at the bottom, paragraph 14, consideration given to the effect of registration and overriding interests. So even when there's no claim, as was the case on the facts here, and then at 2133, paragraph 15, is the key passage where it said, challenge was made.
Sorry, which paragraph are we?
Paragraph 15, my lord.
15, thank you.
I'm jumping a little bit to jurisdiction here, but the point for the purposes of question 1 is no claim was brought. That wasn't a problem. Paragraph 15 then criticises the judge's decision on the basis that there was non-compliance with sections 94 and 96. That's the bit which says that the registrar, an application is made to the registrar if you've acquired land by prescription. Those sections are not what section 28F refers to as the laws relating to limitation and prescription. These provisions deal with a procedure which may be utilised by any person who wishes to make a claim for registration of title claims have been acquired. In my view, the laws referred to by section 28F are the provisions of the 19th book of the Civil Code. And then 16, article 2103A stipulates the court's jurisdiction to declare prescriptive title, and it provides. So the absence of a claim, my lords, wasn't a problem.
So I'm not sure I fully grasped the facts of this case, but at the time of first registration, was there an accrued right based on adverse possession?
Yes.
Yes.
There was an accrued right, and there
based on 30 years adverse possession.
Indeed, and there'd been no claim brought.
No claim brought.
Yeah.
But the court, and the order made by the court was
to cancel the registered registered owner's title, and to reinstate. It's the paragraph 20. Reaffirm the order of the trial judge. Title had been acquired by prescription and registration be cancelled. Paragraph 20.
Were the arguments which arise on this appeal raised in this case?
But it was necessary to bring a claim.
Yes.
No, but they were raised, my lord, by Mr. Theodore in the case. Sorry, just bear with me while we're here. In the case of Edwards, which is at 2326. Um, 2325 is where it starts, I think.
I think that's paragraph 8.
No, it actually starts, it starts at 2322, but in Edward, the court expressly considered and dismissed an argument by Mr. Theodore on behalf of the claimant that the defendant had lost rights, including overriding interest on the basis they'd failed to claim. And that can be seen, 2326. issues.
That was issue 2 in paragraph 14.
Yeah, issue 2, exactly. And 2334, paragraph 34, poses the question.
2, 3. Which was the page again? 334. Okay.
2334. Which poses the question as, since rights were never adjudicated, the question to be answered, what should have happened to his land? And then Forty-five at 2336. Points made that the adjudication officer didn't proceed as if he'd made a claim in the absence of any claim having been brought by him.
Where do we get to the conclusion?
I'm getting there. So 54 at 2339. I'm trying to get to the conclusion. I'm sorry. So it's 2340. 2340 at paragraph 58. Sorry, took a while getting there. Although Mr. Edwards has lost his right to claim under the deed of sale, he has an overriding interest in the land he presently occupies.
So where is that?
Paragraph 58 at 2340. 38.
58. Sorry.
58.
Oh, yes, I see.
This is one of the cases we cite in our written case as supporting our position on jurisdiction. But it also, we say, supports our case on no claim needing to be brought.
I see. This is
And that was a first instance decision.
That is a,
I think.
it's a,
One.
Yes. Mr. Justice Edwards.
So I'm just flicking back.
sorry, so am I. Apologies.
Page
High Court,
2322.
yes, High Court.
Supreme Court. High Court.
High Court.
And this was on section 28G.
Yes, but there is reference to section 28F in the course of the
Well,
judgment.
that was my question.
Yeah.
Why G rather than F?
Yeah. Well, prescription is the subject of paragraph 58, which is squarely F. Maybe it's a typo.
So you say this is actually about F?
Well,
But
I say it's about, well,
the previous paragraphs are all talking about G.
they are. Well, I say it doesn't. I say it doesn't matter. We might get to the bottom of why reference to G and F are made, but it doesn't matter because the point I'm drawing from this, my lord, is that the absence of a claim in respect of an overriding interest, which could be F, could be G, was not fatal.
Yeah.
That's
And once
the
you've got a right based on prescription,
yes.
then you fall under G as well as F.
Indeed, if you have a right that's capable of exactly falling within the subject of G, there's an overlap between the two.
Providing you're an application, but if you're not, you're in danger anyway.
There needs to be content to G. Yeah.
But just on that, I mean, that again is slightly curious because G is qualified, save where inquiries made of such a person, the rights are not disclosed. So you can lose those rights, but under F, it doesn't seem that you do lose those rights.
And there's reference in the Law Commission to report to that inquiry. It's again the same language as section F70. I didn't take you to that because I'm conscious of time, but there is a reference in there. And insofar, my lords, as you need to look at that, the page number is 2681, paragraph 2.59, and 2684, paragraph 2.64.
Thank you.
I'm about to leave the LRA, but before I do so, I want to just flag section 115, which is at 2090. Took your lordships to section 80. Well, I'll take you to this again under jurisdiction, but 115 reserves the court's jurisdiction to try claims, you'll see, relating to the ownership or the possession of land registered under this Act, being an interest which is registered or registrable, or being an interest which is referred to in Section 28, shall be tried by the court, and the court is defined by Section 2 as being the High Court. And we submit this is also inconsistent with the suggestion that you must bring a claim as part of the adjudication in relation to overriding interests. So, my Lord, if I can invite you then to turn to the LAA, the Land Adjudication Act. I've made the point that given the existence of Section 28 and the fact that the Court of Appeal's reasoning would result in the loss of rights across the board, there needs to be clear language. And we say there's no sufficiently clear peg in the LAA on which to hang such a construction. Section 6 at 2024 is a provision for notification by an adjudication officer, shall prepare a separate notice, and little c, require any person who claims any interest to make a claim either in writing or in person within the period and at the place and in the manner specified. My Lords, we say that this simply contemplates that persons claiming interests may bring a claim and sets out the manner in which such claims are to be brought. It's a procedural provision, we say, about the form and content of the notice that the adjudication officer must publish. It says nothing about the effects of failing to make such a claim on acquired rights, or indeed rights in the course of being acquired. Section 6.2 over the page, my Lords, is the service provision. It provides that the adjudication officer shall publish the notices at its offices, and B, cause the substance to be made known by publication in the Gazette or at least one local newspaper. There's no provision for personal service, and my Lord, this is important when I take you to Graham Davies, the board's decision, because one of the policy justifications for the construction of the scheme in that case was, one, there was a specific carve-out, and two, in the absence of personal service, it would be wholly unfair to deprive a person with rights. And here too, you have no personal service. Section 7, my Lords.
Just before, sorry,
Yes.
what do you say about 6.1c?
6.1c requires any person. Yes, we say, my Lord, that's a procedural provision about the form and content of the notice and the manner in which a claim, if it is to be brought, needs to be brought. So
it's about what the notice has to contain.
And what the notice has to contain, exactly.
I mean, there is it's fair to say, isn't it, under Section 6.2b, that the adjudication officer is under a statutory duty to give notice in such other manner as he considers to be the most effective for the purpose of bringing it to the attention of all persons affected thereby.
Yes. My Lord,
that's in addition to any advertising.
Well, my Lord, that's not dissimilar to our alternative service provisions in our...
Well, maybe, but I'm not sure. Maybe you're right, maybe you're wrong about that, but there is a clear statutory duty on him he chooses, but he has to choose what, in his view, is the most effective purpose to bring it to the attention of all persons affected.
Indeed.
So your point is that despite the very best endeavours, there are some people who might slip through the net.
Indeed.
That's your point.
Well, that's my point. There's no, in the absence of personal service, you can't ensure that people actually know, and they lose their rights even if they don't know.
Well, of course, if they're on the other side of the world for a few months.
Yes, or they might.
What do you do?
My Lord, that's one point.
Yeah.
The other point is they may not be familiar with the adjudication process. They might see something in the Gazette. They may not. The third point is they may not be.
That's all part of his duty, isn't it?
Well, it's part of his duty to do the best he can to try and bring it to the attention, but that doesn't guarantee that it will be brought to the attention.
Nor will he necessarily know in relation to a given person whether they're affected thereby or not.
Indeed. Indeed. So it's back to clear words. Well, so this is simply a policy.
How did your clients, because we know that they did have notice of all this, don't we?
They did know, yes.
Yes. How did they find out?
They had a conversation with the adjudication officer. This is.
How did they find out?
I'll have to take instructions.
We can find out.
Yes.
But I mean, if someone's actually in occupation of land, in adverse possession of the land, it it'd be pretty obvious that they're there.
That's a point that is against my learned friends, if I may say so.
Why?
Because it's not too burdensome for an occupier. What you do by Section 28, there's a carve out for the policy.
Hold on, but I mean, all I'm saying is it would be very easy for the adjudication officer actually to give personal service.
Well, you might think so, my lord, but not necessarily. Land is vast, and one can't necessarily assume that it's easy. It might be difficult terrain to access. It might be it might be a vast swathe of land. One doesn't necessarily know where they're not.
This is all speculation.
Well, exactly. But that's the danger of making.
There's the statutory duty.
There's a statutory duty to try and bring it to the attention, to do what one can, yes. But my point is that there's no provision for personal service, which is a point that Lord Jauncey and Graham Davis relied upon when construing the scheme in that case, in the way that we say it should be construed here. Section 7, my lords, is a provision about the staying of land suits in any civil court until proceedings under this act have been completed. My lord, we rely on this to say that this points against everything being dealt with at the time of adjudication exclusively by the registrar. Section 8 is a reference back to Section 6. Every person, including the Crown, claiming any land shall make his claim in the manner and within the period fixed by the notice. Again, that says nothing about the consequences of failing to make a claim. It simply stipulates how the claim is to be brought, i.e. in accordance with what's said in the notice and in the time period. And it's land or an interest in land, which a person in the course of acquiring rights would not yet have.
But if you already had accrued your 30 years, you would have.
You would have. You would be able to bring a claim, but then the question is, does one need to bring a claim?
Well, that I agree.
Indeed.
You would say it doesn't apply to being acquired.
Doesn't apply to being, can't apply to being acquired. And if it can't apply to being acquired, then but one needs to read Section 28 as a whole, because it contains a composite category.
I don't quite follow that, but I mean, if you read this as applying to someone with an accrued interest, you can then say, well, they're under a statutory duty to make their claim.
Yes, but one still needs to read in a qualification to Section 28, which, as I'll take you to 23, this takes subject to the Land Registration Act. So one needs to read into the express exception under Section 28, a qualification. It will operate as an exception if a claim is brought.
Yes.
And those words don't appear. Section 9.
So you say, where you're in the process of acquiring a right, you haven't got the right, so you can't possibly make a claim.
Yeah.
Where you've got an accrued right, although you could make a claim, there is no requirement for you to do so.
Indeed. And if that were a requirement, it should have been spelt out because of the consequences.
Well, it is a requirement, but your point is that the consequences are not spelt out. So in the old language, it's whether it's mandatory or directory. Really.
Well, there's a requirement. If you are going to bring a claim, you have to follow the procedure set out in Section 6 and 8. But the requirement is not to bring a claim.
I see. So it's only applying, you say, to someone who is actually claiming.
Indeed.
And it just tells you how.
Exactly. That's why I say it's a procedural.
Nice if we had a short word for someone acquiring and someone with an accrued right.
Yes.
But you say it doesn't apply at all to the first category.
Yes.
And it's only directory in relation to the second category.
Indeed.
Yeah.
Well, Lord put it much better than me.
But if you do make a claim and it's adjudicated upon and
Yes.
you lose, is that what happens then?
You can't go back because then you've got Section 98, which is rectification of the register.
Yes. Okay.
And the line of case law, which my learned friend quite rightly relies on in relation to all of that, would apply, but it's inapplicable to what we're contending here.
That would be so even if you just raised it as a defence to a possession action.
Yeah, I think so, yes. Section 9, my lords, 2026, confers discretion on an adjudication officer to proceed as if a claim had been made, if satisfied that any person who has not made a claim has a claim. So that's we've discussed this very briefly, touched on it briefly earlier. I say the purpose of that is to try and mop up things if possible, so as to avoid the burden being too onerously placed on the court in due course under Section 115. So that it's perfectly possible to read Section 9 as empowering an adjudicator in an appropriate place if it's clear that there is a claim so that the officer can deal with. And then 2028, taking you to Section 15. Disputes, that enables the adjudication officer to adjudicate and determine any dispute. And then over the page, 2029 is one of the provisions the Court of Appeal referred to, which allows the recording officer to record prescription if they're satisfied that a prescriptive claim has been made out.
So, sorry, which provision are you focusing
So
on?
if the recording officer is satisfied that a person is in continuous, uninterrupted, unequivocal, peaceable possession, that reflects, my lord, the language of this relevant part of the Civil Code, other than, and has for a period of 30 years or more, that's subsection 1, or has, subsection 2 is good title, we can jump over that. The recording officer shall record that person as the owner and declare his title to be absolute. But then over the page, my lord...
Before we go over the page,
Yes.
Roman numeral 16.1a, Roman numeral 2.
Yes,
That's envisaging that someone has got a good title to the parcel,
yes,
paper title, okay, and that no other person is in the course of acquiring rights, okay. The recording officer shall record that person as the owner of the parcel and declare his title to be absolute. Okay. So, in this case, if in fact your clients were in the course of acquiring a title, there couldn't be a declaration of absolute title.
no.
And then could there be a declaration of provisional title in such circumstances?
Yes.
Why? Because if you go over the page, recording officer is satisfied that a person is in possession. This is a provisional title to your client, okay? To the paper owner, to the paper owner. The recording officer, this is all about, D is not about the paper title holder, it's about the person in possession.
Yes.
So what title do you register for the paper title holder if there is a person in possession acquiring a title?
Well, 16A enables the recording officer to consider a prescriptive claim. So that's 16A, Roman numeral 1, and to record that person, i.e. the person asserting a prescriptive claim, as the absolute owner, if the recording officer is satisfied that the evidence is sufficient. So what this does, my lord, we say, is empower the recording officer to, in the course of its quasi-judicial function, to consider prescriptive claims that are brought before it at the time of adjudication.
Okay, so assume that a claim has been made.
Yes.
A person has claimed, I'm in the course of acquiring a title. Okay, and what's the recording officer to do?
Well, in that circumstance, it could either dismiss the claim on the basis that it doesn't consider the evidence is sufficient.
And if it finds that it's sufficient, that the person is in the course of acquiring a title, what's he to do then?
Well, it could decline to register, and there's section 115 of the Land Registration Act that we looked at confers on the court jurisdiction to determine claims relating to overriding interests.
Right.
So it could pass it back, and you recall, my lord, I took you to section 7, which says court claims are being stayed until after the adjudication process is completed. So it could do that, or it could record that person as owner with absolute title, regardless of the other person who is in the course of acquiring, but that title would take subject to overriding interests pursuant to section 28. Does that answer my...
The trouble is that I don't quite know what the court could adjudicate on, because someone is in the course of acquiring but hasn't acquired. So,
well, maybe this is to be read as only entitling the recording officer to register a person with absolute title, if they are satisfied that there is no such other person. Because in the...
Well, that's how it reads like.
Yes, if there is another person who pops up or appears to the recording officer that there might be such a person, then it would step away from its power under Section 16 and would leave it for the court to determine the claim under Section 115.
But what claim?
115, what of the Land Registration Act?
Yes.
What if the adjudication officer finds somebody who's squatting and he's been there for 1 year and he's just a happy squatter?
Yeah.
And in answer to a question, are you in the course of requiring a prescription? His eyes sort of glaze over. What does he do there?
Well, this presupposes that a claim is being brought before the recording officer by a person asserting prescriptive title. So that's what Section 16A1 deals with, because they need to be satisfied, firstly, that there is a person who is in occupation for 30 years or more. So that's the context within which the recording officer is going to consider the claim.
Well, sorry, I thought we were focusing now on little 2.
We are, but the context for little 2 is the recording officer being asked by a person who has the complete period.
The problem doesn't go away just because somebody hasn't made a claim. If the recording officer is satisfied, could be construed on the basis that somebody has made a claim, it has been adjudicated or whatever, or attempted to be resolved. But the problem still persists. That for instance, that an absolute title can be registered in relation to a paper holder, but a provisional title can only be registered in relation to a provisional holder. Sorry, a person in possession.
Yes. Well, my lord, all I think I can say about that is this Section 16 doesn't mandate the recording officer to do anything. It may. It's discretionary provision. It doesn't say they must be captured on the record.
Sorry, 16?
Yeah.
It says shall record.
The recording officer shall record.
But if satified, so it depends on the circumstances.
Well, that's his job, isn't it, to be satisfied or not satisfied?
It's not a discretion.
No.
So if he's satisfied.
Well, yes.
I don't know how one really works out a little 2.
I rather thought that was the point of Lord Briggs's example, that within little 2, you've got your squatter there for 1 year. How can the recording officer be satisfied that there is no person in the course of acquiring a title?
I mean, in a sense, every squatter is in the course of acquiring a title. It's just a question of how long he gets to squat.
Yes.
It's something to do with his intention, well, I don't know enough about the civil code on prescription, but I'm assuming it hasn't got much to do with intention.
No, it's not. It's similar to adverse possession. You have to.
You basically have to assert your rights as a property owner.
Factual possession, intention to possess.
If you put a fence around the property.
Yes, indeed. Enclosure is exactly. It's the same as our common law system in that regard. My lord, can I think about it overnight? Yes. Because clearly I don't have and see how that might work. But yes. I can see why your lordships are asking the question.
And what does subsection 2 mean? It refers to articles 2056 and 2064 of the Civil Code.
Yes.
For a person in possession. Is that?
Yeah, we've got those, I think.
Oh.
Yeah. (2788). It's simply, there's simply provisions that the possession of a person needn't go up, taken unless you want to, but the possession of a person must be continuous and uninterrupted, peaceable, public, unequivocal, and as proprietor.
Do you get anything from 16(1)(c), which appears to be a sort of catch-all designed to require particulars of any registrable right, even if it's not outright title?
Yeah, thank you, my lord.
To be recorded in relation to the right you're asserting, which is an overriding interest.
Yes, so if, and that could work in conjunction with the little Roman numeral 2, so if a person in your Lordship's example popped up, and they were satisfied that that was a right which was registrable.
Well, I mean, the point is that if it's an overriding, well, an overriding interest is sort of registrable,
yes,
but it doesn't have to be.
No, it's registrable, there's no doubt about that, but it doesn't have to be registered because of the bottom of section 28, which, my Lord, you asked me whether I was going to skip over.
Yes.
It makes it clear that it's registrable.
Yeah.
So, yes, I do take something from that. And I also take from the fact that there is an express reference to the Civil Code in subsection 2. That's a point in my favour on the jurisdiction point, because it's quite clear that the Civil Code is to be retained for the purpose of this scheme. My Lord, I'm conscious of time. I'm still at question 1, so I'm going to move on, and it might have to be a canter. But in summary, my Lord, actually, before I leave the Adjudication Act, 2032, sections 19 and 20, you'll note 20 is finality provision, and there's a provision to appeal against the adjudication record. And further down the page, my Lord, at 21 and 22, there are provisions for corrections disputes. But then you've got section 23 at page 2034, which is an important section for our purposes. Yes. Finality, after the expiry of 90 days, the adjudication record shall, subject to the provisions of the Land Registration Act, become final. So, my Lords, in a nutshell, if I can summarise our case on a statutory language under question 1, we say that the reasonable reader looking at the scheme would note that adjudication and certification under the LAA take subject to the LRA, that's section 23. They would note, my Lords, that section 28 of the LRA expressly makes title subject to a list of rights not requiring registration, and that protection is not...
Sorry, so the reasonable reader would note that the adjudication process takes, or the adjudication takes subject to...
the Land Registration Act provisions, which include section 28, which expressly stipulates that the certificate will be subject to a list of rights which don't require to be on the register, and that protection is not qualified in any way. And they would note that that meant that all the listed rights in section 28 were preserved from being lost in the welter of registration, if I can coin Lord Denning's phrase in the Strand Securities case. And they would, my Lords, note that the list of protected rights includes rights in the process of being acquired. And they would form the view that it wouldn't be possible to bring a claim in relation to those. And they would note section 7, my Lords, of the LAA, which envisaged that civil claims can be brought after adjudication has completed, and that section 115 reserves jurisdiction for the court to determine overriding interests, my Lord.
Section 7 of?
The LAA. And my Lord, if the reasonable reader looked at the certificate itself, which is at 2097...
just on section 23,
yes.
you rely on this, do you? Section 23?
Well, simply because LAA, once you complete the process, you've got a certificate. The certificate is subject to the LRA.
But it says that the adjudication record, is that right?
Yes.
Shall, subject to the provisions of the LRA, become final.
Yes.
But is that not referring to the provisions of the LRA, or the mistake provisions? Are they in the LRA or the LA?
They're also in there, yeah, subject
in the LRA?
Yes.
But
so there are two cards.
Isn't that what that's referring to, really?
Not necessarily, my Lord.
I mean, it's still final, even though it's subject to overriding interests,
right.
isn't
yes.
it?
So insofar, yes.
So I don't think... It doesn't really look to me like a reference to section 28.
Well, my Lord, perhaps the point I'm making is that they are, as the board said in Lewis, and two interlocking components of the same scheme. And I was about to take my Lords to the certificate, which is at 2097, which the reasonable reader would see, which specifically says that the certificate, title absolute or provisional, is subject to such overriding interests set out in section 28 as may subsist and affect the land.
So just 1 second.
So just give me the page again.
2097.
This is a standard form
Yeah.
It's in a schedule, right?
Yes, it's a form that's mandated by the regulations, which we don't have, my lord, but we looked at, and it's in a schedule to the regulations.
Yes.
Yeah. My lord, can I take you briefly to authorities that we say support our position? The two cases that and I may not be able to get there, but we've got the two cases are Graham Davies, which is at 2299.
Sorry.
Graham Davies, a decision of the board at 2299.
Thank you.
2299, it's a decision of the Privy Council from an appeal in Antigua. And the facts are set out in our written case, but briefly, my lords, the case concerned whether the appellants claimed to be entitled to possession of land called Bluff by virtue of the fact that they had the registration in their name. So in a sense, they were in the position of the respondents here under the legislative scheme in that case, which was the Land Adjudication Act 1975. And the respondents, for their part, claimed to be the owners as a result of sales by someone who had possessory title under the limitation provisions of the Real Property Limitation Act. And the issue, my lords, was whether registration was subject to those possessory rights, which may have subsisted at the time of registration. And my lords, the key passage, the scheme is at 2306G, which refers to the fact that prior to the 1975 legislation, there had been a previous act dating from the 1887, which involved judicial approval. You see that against letter J, rather. Initial registration required judicial approval. And over the page, my lords, in that legislative scheme, title was said to be indefeasible, and indefeasible had a specific definition, which you see at the top of page 2307. Two exceptions in the definition. Fraud, so similar, we'd say, to section 98 here, or that the title has been superseded by limitation. And the time period for those purposes was 12 years. And then section 34 of the Title by Registration Act provided for a person who claimed to have acquired by prescription to present a request to the registrar to have a certificate of title issued to them. And then 2308, just over the page, my lords, against letter G, there was also an express carve-out for overriding interests. See at the bottom of page 2308. And at the top of 2309, rights acquired on the process of being acquired. So the recording officer, at the time of the claim being brought, referred the matter to the adjudication officer in accordance with section 15, and the adjudication officer said he had no power to vary. And the reason for that is on the specific language of section 15, which you'll see at page 2308 against letter D. That legislation didn't empower the adjudication officer to vary an interest. It required the officer to carry forward the previous registration. So that's different to what we have here. Back to 2309, Dr. Ramzahoy, who was the counsel for the certificate holder, argued a few things, but amongst those things against letter G was, you'll see there, they hadn't raised the question of prescriptive possession before the officer, and then he says, just below H, in any event, title having been registered, any prescriptive period must run from the date of that registration, which was less than 12 years. Their lordships have no doubt that these arguments are unsound, and this is the key. And I'd like to invite your lordships to look at the reasoning. The scheme of the 75 legislation was that an interest registered would be registered under the 75 register without alteration, but that such registration would not affect the existence of overriding interests, such as rights acquired or in the process of being acquired by prescription. This was an eminently logical approach, since many of the overriding interests detailed are of a character which might very well not be apparent in the performance of his duties. It would be manifestly unfair that a person who had acquired or was in the process of, and upon whom no specific notice had been served, upon whom, should forfeit such interest simply because he had not become aware of the publication. It was no doubt one of the purposes of Section 28 to avoid such unfairness. And then they go on to say, Lord Jauncey goes on to say, in their Lordship's opinion, the proviso left the officer with no alternative but to record the ownership should be vested in the appellants. He made no decision, leaving it to them to pursue their remedies through the courts. It follows that they did not lose any overriding interests and in no way are barred from seeking now to enforce those interests. Now, my Lord, it's said against me that it's the distinction between that case and this one is that the adjudication officer didn't have the power. We say that's not the ratio of the decision. The features which drove the construction in Graham Davies are equally present here, namely the fact that there was an express statutory directive, all lands being subject to overearning interest and no personal service, and the policy considerations set out against C. The reference to Section 15, just by C, left no alternative, was referring to the consequences and also to the fact that no decision had been made, so they were left to pursue their remedies. There's no res judicata point that arises. The character of the rights which arise informally is entirely consistent with how the Law Commission viewed it, and the same manifest unfairness applies on the facts of our case. The fact that there is a quasi-judicial power for the officer to consider prescriptive rights in this case does not remove the unfairness which Lord Jauncey had in mind.
Would there not also be unfairness if there was someone with a rival paper title who was unaware of the process?
Conceivably, yes.
I mean, supposing he was on the other side of the world for 6 months,
yes,
while the process went on, it would
yes,
be unfair to that person, wouldn't it?
Yes, my lords.
And
my lord,
they lose, don't they?
but their balance has to be struck, and perhaps the balance is an imperfect one, and it can't cover all situations.
Takes a little bit away. Maybe it proves a bit too much, doesn't it, this particular point about unfairness?
Well, my lord, in circumstances where it's a question ultimately of statutory construction, and I recognise
that I think is why Lord Jauncey was looking at the proviso.
Indeed, and
Section 15.
I accept that the provisions of our legislative scheme are not entirely aligned with the provisions.
So even if you're wrong about the ratio of this case, you'd say, well, that doesn't affect the proper approach to the St. Lucia legislation.
Yes, well, I'd say exactly for the reasons I've already espoused. We say that the St. Lucia legislation should be construed in the way that we're contending for.
Lord Jauncey doesn't refer in this reasoning, does he, or does he, to the terms of Section 28 of the Land Registration Act, which is part of the sheet anchor, really, of your submission?
Well, he does, in the sense, against A, eminently logical approach, since many of the overriding interests detailed in Section 28. So, my Lord, what we're saying is what's really driving Lord Jauncey's conclusion are two things. First, there's an express carve-out, and second, the policy considerations for removing from such a person with the benefit of the express carve-out. And I recognise, my Lord, that wouldn't apply to everyone, but remember that the list of overriding interests is intended to catch a certain category of rights which may arise informally, perhaps not somebody with a paper title. And those two things in combination are what drives the construction that you don't lose your rights in the absence of clear words to the contrary. So,
well, he does say that 2310 letter C was one of the purposes of Section 28 to avoid such unfairness.
Exactly. Yeah, indeed. And we say that very purpose is equally applicable here, and the Court of Appeal were wrong to distinguish it.
Yes,
my Lord, can I move on, because I've only got half an hour left, to George and Guy, which is at 2197, which is a decision of the Caribbean Court of Justice. We deal with this in our written case at paragraph 66, but it's important, so I need to take you to the relevant bits. The facts are essentially that George George, the appellant, had been in long occupation of a strip of land for 12 years. Guy, who was the respondent, had the certificate of title. George didn't bring a claim at the time of registration, and Guy sought possession sometime later. George defended that on the basis that the claim was statute barred and title had been extinguished under the Real Property Limitation Act. Guy relied on the indefeasibility of his title. So the Dominican legislation, my lords, are referred to, essentially it referred to at paragraph 4. It's the indefeasibility provision, again. And that's to be found, just for your lordship's note, at LS 78. That's the Caribbean bundle. Essentially, indefeasible except on the grounds of fraud or supersession by title. It's really similar to the one we've just looked at. 2199, paragraph 5, both the trial judge and the Court of Appeal accepted Mr. Guy's argument, namely that he had his title certificate and therefore he wins. The majority of us have a different view. In our opinion, Mr. George's defence, that's a defence to the claim for possession, is well made and his appeal succeeds. 2199, paragraph 6 refers to the legislative scheme. That's the Real Property Limitation Act, squatters' rights, 12 years. And then paragraph 8 on the next page, no formal procedure to mark the extinguishment of title after that period. Well, that's the same here under the Civil Code. And then paragraph 9, my lords, the other legislative piece is the Title by Registration Act. Nothing in the TRA, second line down, states it was an act to amend the Limitation Act in any way. The purpose was to enact a system of land ownership that's been adopted by some countries, Torrens. And then at paragraph 10, last sentence, the legislative scheme has been aptly described, and that's the purpose of the scheme. And then in paragraph 11, my lords, indefeasibility is not absolute. Two exceptions. One is fraud, and then the second and the last sentence is the one that's relevant, namely paragraph 12, where there's limitation. And then 13, the points made, providing an exception for adverse possession is a feature common. And then, my lords, paragraph 14, in making this exception, the TRA accepts, recognises and endorses the notion that ownership rights may be extinguished, supplanted, superseded. Far from qualifying. And then section 33 in that paragraph is said to be a mechanism for formalising those rights. So a person with, 12 years can defend a claim, and what section 33 is said to do is to provide them with, if you like, the sword, the mechanism to strengthen their position and formalise the claim. Pausing there, we say that there are similar mechanisms here. I may not have time to take you to them all, but essentially they're to be found in sections 115 and section 80. And my lords, then there's reference in paragraph 15 to Graham Davies. And then if I ask you then to look, to skip forward to paragraph 31 at 2210. Paragraph 31. Which is a reference to what the Privy Council were doing in Graham Davies. Over the page, my lords, at 2211, Lord Jauntie's comments are better interpreted to mean that the name attached to a registered title may only be replaced by the name of a squatter who has dispossessed. If the squatter has followed the section 33 procedure, so that's the claim point. And then 32, my lords, there's reference to that particular legislation doing four things. It affirms the LPRLA, and we say that's similar to the Civil Code, the rights given to squatters. Secondly, it provides that the rights are exception to indefeasibility. Thirdly, it provides a process whereby you can convert your rights into a more positive case. And fourthly, you have, if you get a certificate on that basis, then you're in the same position as the previous holder. And then finally and importantly, my lords, if I can take you to paragraph 34, where it said, some may consider the concept of indefeasibility with all the commercial advantages that should bring sits uneasily with the idea of adverse possession superseding such a title, but for better or worse, that is precisely and expressly what the TRA allows. If this seems odd, then it's for Parliament to address by removing or qualifying the second exception. Now, that's the exception for limitation or prescription. Now, and this is the important bit for my purposes. Some states have adopted that approach. The United Kingdom Parliament, for example, did so in 2002. And as you will have seen, that was in relation to overriding interests. And there's a reference earlier on in the judgment, I think, which I didn't take the lodge, it's 2.2. It's the bit where it says it's common feature, paragraph 13, 2201, which refers to overriding interest being another way to do it. 2201, paragraph 13.
But there wasn't an overriding interest provision as such.
No, but it's quite clear that it's equivalent. Where's it says? Excuse me. We'll find it, but in there's a reference to, in some, it's common to the torrent system. In some cases, it's dealt with by way of overriding interest. Here, it's dealt with by this indefeasibility provision. 25, paragraph 25, which is at page 2207. Over the page 2208. Yeah, last sentence. So 25, my lords, and 34, which is the reference to the United Kingdom having changed it in 2002, makes it quite clear that for our purposes, there's nothing to be distinguished between the approach in this case, statutory scheme in this case, and that in our case. So the Court of Appeal wrongly distinguished George and Guy. It's entirely analogous. Here there are equivalent mechanisms to be found in 115, Section 80, and Sections 94 to 95 to enable my clients to claim. So, in the short space of time I have left, I'll take question 2 very briefly. The prescription period is not interrupted. My lords, if we're correct about the claim not being necessary, then we win on this point. There's no reason why the prescription period should be interrupted. But in any event, it's clear we say from the statutory language that adjudication doesn't interrupt that period, and that conclusion is consistent with both policy and authority. So far as statutory language is concerned, we've got the words in F, course of being acquired, which we say envisages protection for a person who has not yet got the benefit of the full period, and the only way to confer that protection is to keep time running. And that's how the words, my lords, were read by the Law Commission. You've got the reference 2674 at paragraph 2.37. It's consistent with the Civil Code, my lords, page 2787, Article 1978, which says that registration does not interrupt prescription. And it's how, my lords, the words were read in Tiabo, which I will take you to very briefly, 2541. Supreme Court of Belize. It starts at 2541, but the relevant bit is at 2554. Where paragraph 34, counsel for Mr. Tiabo raised that 12 years should be calculated only against Mr. Tiabo's proprietorship, so that's essentially when he was registered, but there is no merit in this. And then if you skip forward, my lords, to paragraph 36, the reference to the recreational holdings case, which found that registered land was subject only to rights acquired over land by limitation since first registration, but that is peculiarly so by virtue of the specific section of the Jamaica's Registration of Titles Act. And if you look at the proviso language in the bold wording, acquired over such land since the same was brought. So there's specific words in there that ensure that the time only runs from the date of registration. The point's made in 37 that the Belize legislation makes no distinction. In fact, it is so wide that it speaks not only of rights acquired, but rights being acquired. This, to my mind, enables time to run prior to and to continue thereafter as if there was no interruption. And he strengthened in that view because of Section 20 6, which outlines the effects of registration with absolute title. Well, that's the same as section 23 here, because ownership is said to be absolute, free, subject to overriding interest. And that's, my lords, unsurprising as a matter of policy. And it wouldn't, as the Court of Appeal held, at paragraph 182, render the scheme nonsensical for time to continue to run. Paragraph 182, page 970. The Court of Appeal, in making that, taking that view, neglected to have sufficient regard to the fact that the scheme is expressly made title not entirely indefeasible. On the contrary, as we said, there's good policy reason for rights capable of being acquired informally to be protected. On prescriptive period, we've also got the fact that in Graham Davies, the board rejected the argument, I've taken you to the relevant passage, that time started after registration only. No doubt that argument was unsound. As per our written case at paragraph 81, we also say the Court of Appeal was wrong to follow the case of Joseph. Joseph is at 2417.
Sorry, page
2417.
17, thank you.
The facts you can see at 2418 are that the respondent sought possession of land as the title holder, and the appellants claims negative prescription on the basis that the respondent was statute barred from bringing the claim, and also counterclaimed for declaration. And there was judgment for the respondent, who is the title holder. But 2462, no, sorry, 2426. Paragraph 15 makes it clear that this was not an overriding interest case. So paragraph 15 shows that the appellants sought to rely on overriding interests, and about 6 or 7 lines down, it starts, the difficulty with this ground of appeal is that no claim was made in the court below, nor was it anywhere pleaded by the appellants that they held or were entitled to be treated as having overriding interest. Not a function of the trial judge to find or formulate issues for a party which had not been pleaded, or to decide a case on an issue which has not been raised. And then, my lords, over the page, just under the reference to Knowles and Knowles, sentence starting, the case pleaded was simply that they prescribed, thus was barred, completely devoid of any averment to overriding interest. To allow this appeal would render the entire case one wholly different from the case tried below. So the court in this case wasn't considering the effect of an overriding interest. It also wasn't considering the effect of Graham Davies. And it's, my lords, not inconceivable that informally acquired rights are protected in view of the balance that, as I say, is to be maintained. George and Guy and Graham Davies are more analogous. The respondent also relies on the Zinner case, which is a case whereby the Court of Appeal extended the Joseph reasoning to overriding interests. That's at 1988. I'm not going to take you to it now, but we say in relation to that, my lords, that it didn't consider Graham Davies. It's simply an extension of the Joseph reasoning, which didn't consider Graham Davies, and essentially we say it's wrong. Question 3, is there a jurisdictional hurdle? My lords, we need to keep in mind here that the overriding interest entitles my clients to rely on qualifying rights both as a defence, shield, and also as a counterclaim, so a sword. So far as the defence is concerned, there's no jurisdictional problem, and the Court of Appeal recognised that at paragraph 204 of their judgment. The reason the claim was thrown out on the defence point was that we'd failed to establish the period. So if we're right on questions 1 and 2, then we're entitled to raise the defence as a shield. So far as a claim is concerned, our position, my lords, is as we say in paragraph 83 of our written case onwards, the Court of Appeal was wrong to find that there was a jurisdictional hurdle based on the James and Plaveron case. The relevant bit of the Court of Appeal judgment is at 201 to 203 at page 978. And essentially what that case held was that the court's jurisdiction under Article 2103A, if you look at just before 202, had been, in the quote, had been rendered redundant. And it was also, so essentially James considered whether the High Court retained jurisdiction under 2103A of the Civil Code and whether that could coexist with the Land Registration Act. The court held that it could not, and that only the registrar could decide prescription claims under Section 94 of the Land Registration Act. The court only retained an appellate jurisdiction, so a supervisory role. And it also held that Section 115, and this is the quote in paragraph 202, 115 has nothing to do with prescription. You see the quotation, the concept of prescriptive involving the recognition of the paper title owner. Effectively what James held was that Section 115 had nothing to do with prescription because the concept of prescriptive, I think, prescription involves the recognition of the paper title owner, and therefore 115 had nothing to do with, didn't confer the relevant jurisdiction on the court. And then equally, it was held that Section 80 of the LRA was to be narrowly construed, and that's at paragraph 40. Perhaps I'd take you to the relevant bits of the decision. 2361 is the page, 2361. 2361, if I can invite you to look at paragraph 40 at 2382. Yeah. Paragraph 40, it's the last sentence. So Section 115, after the words in parenthesis, expressly retains the court's jurisdiction in respect of civil suits relating to ownership or possession of land or an interest in land. Pausing there, they don't say overriding interests as the forum to try such cases, because James wasn't an overriding interest case. And then 41, the instant case is not in the nature of a dispute as to the ownership of the portion, as the very concept of prescription involves the recognition of the paper title owner against whom the person claiming is said to have been prescribed. Similarly, it's not a claim for possession. So that was their construction of Section 115. And then Section 80, they refer to it at paragraph 42. Section 80 is the section which mandates, if you like, the registrar to register in the name of someone who has acquired land by transmission by virtue of any order. And we say that applies to an order following the acquisition by operation of law. And here in paragraph 42, essentially they conclude that it doesn't, the wording is to be construed narrowly. It has nothing to do with rectification of the land register. And therefore there's a missing link. Now, my lords, can I take you to those two sections and tell you why it is we say that they can be construed as providing the mechanisms for the court to have jurisdiction? 2090 is 115. Whereby the court retains jurisdiction to try claims relating to the ownership or possession of land registered or interest under Section 28, and that's the High Court, per Section 2. Such determinations, my lords, will result in a court order, and we say, therefore, that 115 can be made to work with Section 80, which is at 2077. Provides for transmission by compulsory acquisition or judgment of the court So where any person has become entitled to any land under any law or by virtue of any order, ... the registrar shall, on the application of any interested person supported by such evidence, register the person entitled as the proprietor. And transmission, my lords, is defined by section 2, that's page 2043, as the passing of land from one person to another by operation of law, on death or insolvency or otherwise. And we say, I took your lordships to the Law Commission report, which referred to the fact that prescription was a form of operation by law acquisition. And we say the wording of section 80 is the language is wide. It contains imperative wording, shall register. It includes any person who has become entitled to the land by operation of law. And that, we say, is the effect of the Civil Code if the full period of 30 years is completed. Similarly, section 28F refers to rights acquired under any law or by prescription. And contrary to James, we say this provision is therefore capable of catching a determination following a decision under section 115 and orders made, which enables us to contend that the registrar is bound to register that person as proprietor. And my lords, we again, in relation to this, rely on the Court of Appeal judgment in Adderall and Gede, which I took your lordships to, where 2131 took your lordships to this earlier, but it's paragraph 15, sorry, at 2133. Paragraphs 15 and 16. It's really 15, the first sentence. Sections 94 to 96 of the Act are not what section 28F refers to. They deal with the procedure which may be utilised. James held that section 94 was the only mechanism, and we say that's wrong. And if I can take your lordships then finally to section 94 to see what it does, and that's 2082, 281. So any person who claims to have acquired the ownership of land by positive prescription may apply to the registrar in accordance with rules of court for registration as proprietor. So our case, my lords, is that section 80 requires the registrar, where there's a court order to that effect, to the effect that a person is acquired by prescription, to register that person. So in a sense, there's a possible tension between section 80, if you construe it in that way, and section 94, which confers a discretion. Because if you look at 95(3), it says, on being satisfied, has acquired, may allow the application and register him or her. So I recognise that there's a potential tension. Two scenarios, my lords. Persons claiming with the benefit of a court order, or persons claiming without a court order. We say, our primary position is that if you have a court order, that's dealt with by section 80. And therefore, the registrar will register. You bypass the need for the person with an order to make the application because of the effect of section 80. And that resolves the tension. Alternatively, my lords, if section 94 and 95 is the process which catches all applicants with or without a court order, then we say the registrar must exercise the 95(3) discretion having regard to the whole scheme with an eye on section 80. If they have an order, then you've got to make the order. So that in that scenario, the discretion is illusory. And a refusal to register in the face of a court order would be appealed under section 105 of this Act, where the court can make any order as the circumstances require, and that order shall be given effect to.
The registrar is in effect dealing with claims for adverse possession, where for some reason or other the paper owner has long since disappeared. Yes. The successors in title are totally unknown, and the registrar makes advertises it or requires it to be advertised in a certain way, and then makes a determination as to whether or not there is adverse possession. And which seems to me to be a totally different procedure than contested claims before a judge.
Yes.
Yeah.
Yes. Finally, on question 3, the other 3 things we rely on are Graham Davies, again, which proceeded on the basis that a person with an overriding interest was able to rely on such rights in court. That's... I don't have the reference, you can get me that. And they wouldn't lose any overriding interests. And we say this scheme should be construed in the same way. Equally, George and Guy, and this is paragraph 84 of our written case, establishes that a person who's acquired rights by overriding interest can equip themselves with the sword subsequent to having the shield. And we also, my lords, rely on the cases in our written case, which are listed, where in all those cases there was no problem, there was no impediment to persons relying on overriding interest in court without having to have recourse to section 94.
Even if you were wrong about all this, a person who had successfully established negative prescription by way of a successful defence to a possession claim could surely then start again and go to the registrar and say, well, here's my court order in the defensive prescription case. I must be entitled to be registered.
One would have thought so, yeah. Don't know if that's accepted, but yes.
But you would say, ultimately...
Ultimately. It's yes, ultimately 94 is a mechanism. We say it doesn't provide the only mechanism. The reason which we want to rely on section 80 and section 115 is that it mandates the registrar, it smooths the process. And we say that on a proper reading and a sensible reading of the statute, that's the natural reading. So questions, the remaining questions, my lords. If we're correct, then my clients had rights which bound on first registration and continue to bound thereafter as an overriding interest. In our written case, we make reference to Ambrister case, whereby the court adopted the unusual course, it was said in that case, to have regard to evidence below, which was not seriously challenged and disregarded by the court in order to supplement findings of facts. It's said against me that the findings of fact are insufficient. We don't accept that. We say everything was squarely before the court. The only reason the Court of Appeal didn't expressly deal with... it found that there was occupation to the north. It relied on the Hippolyte survey, and you'll see at paragraph 50 of the Court of Appeal judgment, which... is at page 919. Actually, paragraph 48 of the judgment is where it starts. There's reference to the survey, and the survey at page 902, the first set of words in bold, the appellants are in occupation of the whole of the land surveyed, engaged in farming and cultivation. They were in occupation of the northern part of parcel 227 for at least 32 years, and held at paragraph 200 of the decision.
Sorry, where's your 200 years?
Sorry.
Did you say 200?
Sorry, paragraph 200 at page 977.
Paragraph 50,
yeah.
That says that the appellants were in occupation of part, not the entirety of the land.
That's because...
Does it say anything about the period of occupation then?
Yes, so, yes.
It does, where?
So, to 200, which is at page 977.
I'm sorry, so not in paragraph 50?
No, not in paragraph 50, and the reference to Hippolyte was the word, it's the whole of that area that they were in occupation of. Paragraph 200, last sentence, if the period were to be reckoned to the 206 claim, the period and use would have amounted to just over 30 years on the basis they occupied before the commencement of the Augustan survey. So they've got the period.
Yes.
There's a finding that they're occupation of the whole. But the Court of Appeal, because it didn't feel like it needed to consider the point, disregarded, it could have supplemented its findings in relation to quality. But the point we make, my lords, and we'd ask you to bear in mind, is that the evidence below was never seriously challenged. There was no evidence advanced by the respondents attacking occupation. Their case was that we've got the certificate of title, and that's good enough. It's indefeasible. And indeed, they couldn't challenge it because they'd only been registered in 2008. and didn't have any knowledge of the relevant period. And there was an admission to that, of that fact in cross-examination. But before I get there, paragraph 86 of the Court of Appeal judgment, the point's made that there was no first-hand knowledge. That's 921.
How about the other 88 people, allegedly? How about the other 88 people, allegedly?
The other 88 people,
yes.
Yeah. It's quite clear on the evidence that they're not on other land, which isn't the area that was occupied. So, and the way I can make that good is if I take you to 1178. We say it just displays the ignorance.
Is this all set out in your written case?
Not these references. Because the 88 people point was in the written case from the respondent, so I didn't anticipate it.
Okay.
I need 2 minutes if I can have them, or I can deal with it in response.
Well, the usual rule is if you do it now, you just get 2 minutes knocked off your response.
Right, well...
You're on the subject, it's probably...
Yeah, I'm on the subject. Can I just take you to, effectively, our nutshell point in relation to this is the assertion that the 88 people are on the land that we're occupying is simply not borne out by the evidence. And that assertion just simply serves to reinforce the fact that the respondents don't know, have no familiarity of the land. So 1778 is a list, and I hope your lordships can turn it round, but it shows that the heading says La Ressource. Yeah, and this is the list that demonstrates that there are 88 people. And La Ressource is a different area of land from the surveyed land. So, and what one gets that from 337. Which is the McKenna report.
Sorry, just give me the reference again.
337, my lord.
337.
337. Shows that La Ressource, bottom right-hand corner, is in the south to the southeast of the surveyed land. The surveyed land is the Aubria land of the defendants, you see. We've got Ravine Rosette on the left-hand side, the wiggly lines around it. If you look at the Hippolyte survey at page 365...
Sorry, just on this map then, the survey land is what?
So the surveyed land is the Aubria land of the defendants, middle of the page. And you see the boundaries, parcel 1021B and 1020B. It might help, my lord, if you...
No, I see. So that's the land that you lay claim to, is it?
Yes, my lord. It might help, actually, while we're here, is to look, if you look briefly at 365, that's the Hippolyte survey. Yeah. If you go back to 337, the McKenna report, you'll see in the bottom right-hand corner, La Ressource is to the southeast of the surveyed land. So it's a different area. My lords, I'd also make the point that none of the 88 are parties asserting rights. There's no evidence from them below. There's been no finding from the Court of Appeal that any of them are in occupation, whereas there's a finding that we're in occupation of the whole of the surveyed land. The reason, and I accept rather unusually, I'm inviting lordships to minimise the need for remission, is that this claim has been going on for 14 years now. It's unfortunate the Court of Appeal didn't deal with the point. We say they didn't deal with the point because they erred at law on the construction of the statute, and it would be extremely unfortunate and unfair, given that all the evidence was before the Court of Appeal, quite detailed evidence about occupation, which was not seriously challenged, the matter to be omitted. And it's for that reason that I'm making a rather unusual, where in circumstances where we say the evidence is there and the declarations that we're seeking, and which I'll put down on a piece of paper over lunch, can be made.
Well, that's a fairly generous 2 minutes.
Yeah. Okay. Many thanks.
Thank you very much. Mr. Theodore.
Thank you, my lord. May it please the court. What I propose to do in my 10 minutes is to simply deal with the key submissions at this point. I will give what I may call an executive summary, where I deal with the key submissions made in my learned friend's written case, and after lunch, I will go into them in a little more detail. The appellant has indicated, or the appellants rather, have indicated that their first key submission is that overriding interests are express statutory exceptions to the indefeasibility of title under the LRA, and the bringing of a claim was not a necessary prerequisite to benefiting from an overriding interest. The short answer to this is the case of the board in Sylvina Lucian and Joachim Rodney Jacob, which is to be found at 2526 of the electronic bundle, and particularly at paragraph 39, to be found at page 2538 of the electronic bundle, that the Land Adjudication Act and the Land Registration Act, in the words of the board, were intended to operate as two interlocking elements of the process of first registration of title. Therefore, sections 23 and 28 of the Land Registration Act, we respectfully submit, must not, as the appellants seek to do, be read in isolation. When the LAA and the LRA are read together as one interlocking whole, the inescapable conclusion is that while overriding interests are indeed statutory exceptions to indefeasibility of title, upon a true and holistic construction of the LAA and the LRA, the bringing of a claim was indeed a necessary prerequisite to first registration because, my lords, of the express language of section 6, 8, and 16 of the LAA, married with the judicial, and that is the words used in the Portland case out of the Court of Appeal. They said that the adjudication process was judicial. The board qualified that in Lucian and described it as quasi-judicial. So when you marry section 6, 8, and 16 with the quasi-judicial aspect of the adjudication process, which our courts have recognized and the board has endorsed, the interpretation that our courts in St. Lucia have given to the statutory scheme is perfectly understandable. It is to be recalled, and my learned friend touched on section 6. Section 6 of the LAA authorized the adjudication officer. It can be found at 2024 of the electronic bundle. That section authorized the adjudication officer to publish public notices requiring any person who claimed any interest in land to make a claim. And in addition to that, as we've also seen, in addition to those notices, he had the obligation to employ such other means as he thought necessary to bring to the attention of persons who might have claims that the process was ongoing. Section 8 of the LAA then mandated every person, including the Crown, who claimed any land or interest in land within an adjudication section to make his or her claim in the manner and within the time period specified by the Section 6 notice. Any person who claimed any interest in land. And Section 16, which is to be found at 2029 to 2030 of the electronic bundle, made provision for persons claiming by long possession or, and this is important, or documentary title to be awarded absolute title or provisional title in the case of those who did not yet qualify for absolute title.
Sorry, which was the provision that you were just referring to?
That would be Section 16, my Lord, to be found at 2029 to 2030 of the electronic bundle. So that's Section 16 of the LAA. In particular, Section 16, 1A, Roman numeral 2, which is at 2029, and D, which is at 2030, authorize the recording officer to recognize the existence of claims to rights or interests in the process of being acquired, or other unregistrable overriding interests.
Where does it say that, sorry?
Well,
That's at 2030?
yeah, 29, 16, 1A, 2. As acquired or is in the course of.
Yes. Does my Lord see it?
Yes, I do, but I don't see how the recording officer hasn't got a duty to record that at the moment. The recording officer is to record an absolute title.
D reads, my Lord, if the recording officer is satisfied that a person is in possession of or has a right to a parcel but is not satisfied that such person is entitled to be recorded under paragraph A, which deals with rights acquired by prescription, of this subsection, as the owner of the parcel with absolute title, the recording officer shall nevertheless record that person as the owner of the parcel and declare his title to be provisional. So that is the provision made. In the event that there is not complete satisfaction that you have in fact, your rights have in fact accrued, and they are still in the process of being acquired, that provision permitted an entry to, permitted provisional title to be awarded to you.
So you say, if we go back to our example of the 1-year squatter,
Indeed.
you say that the 1-year squatter has a provisional title that must be recorded.
That absolutely, my Lord.
And then how about the paper title? Does that also have to be recorded as an absolute title?
As far as the paper title is concerned,
You can't have a 1-year squatter having a provisional title and the person who has got a paper title having no title whatsoever.
the Act contemplated that the person with the paper title would be dealt with at page 2029. A, if the recording officer is satisfied that a person Roman numeral 2, has a good title to the parcel, and that no other person has acquired or is in course of acquiring a title thereto under any law relating to prescription or limitation.
So if I may pause you there, if the squatter has been in possession for 1 year, the person with the registered title can't be registered. Is that right? As an absolute title?
Well, I think the answer to that, Millard, is at the end of the day, the adjudication officer, and that is in fact why we have jealously guarded the adjudication process. The adjudication officer would have to make a determination.
The adjudication officer determines that the person has been in possession for 1 year.
Yes.
Now what does he do? Now what happens? There has been an adjudication. It has resulted in 1 year squatting rights. But the person with the paper title, is he entitled to be registered as an absolute title?
I think, Millard, that the person with the paper title in that situation would be entitled to be registered as the registered proprietor of that parcel. A note would be made in the usual course to indicate that there is, in fact, this other person who is in course of acquiring rights by prescription.
Mr. Theodore, I think we've probably got past your executive summary.
Yes.
There'll be lots more interesting questions after we
Very well, my lord.
adjourn. I think nonetheless we ought to carry on at 2 o'clock to keep up with the minute.